You sought an order in terms of confidentiality of certain parts of the lifestyle audits
Yes.
of the certain members of the board of directors of the PIC. Just want to read out that order.
Thank you, Mr. Commissioner.
Having considered the documentation contained in the lifestyle audit reports compiled by PricewaterhouseCoopers and the submissions by the chief evidence leader, I make the following order. 1. The affidavit deposed to by Lionel van Tonder can be made public and can be posted on the official website of the Commission. 2. The entire contents of paragraph 6 of each of the lifestyle audits of the individuals are confidential and may not be made public. Dated 14th August 2019.
Thank you, Mr. Commissioner.
Yes, Mr. Naidu, can you just stand up, please? Your full names?
Jayendra Naidu.
I understand you are prepared to, I don't know whether to say take an affirmation or make an affirmation. Am I correct?
To affirm.
Prefer that instead of an oath?
Yes.
Yes. Do you affirm then that the evidence you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Thank you. You may be seated. Yes.
Mr. Commissioner, we had a discussion before we started, and we agreed that certain parts of the statement can be taken as read.
Yes.
We will deal with that when we get to that, and Mr.
Van Niekerk?
Van Niekerk, sorry, will proceed.
Yes, thank you.
Thank you, Commissioner. I had also indicated to my learned friend that as I go through the statement, I would imagine the first couple of pages will go quickly as Mr. Naidu takes you through his personal history, how he got to where he is. But then with your leave, Commissioner, it may well be easier if he then takes questions and if for any reason you need to interrupt to get clarity or have questions, he would prefer to do it in that way as we progress through his statement. And of course, anything else beyond the statement that we hadn't dealt with, which requires clarification, he will then take those questions as it pleases. You would want to start with reading through the statement.
Okay. Yeah. Thank you. Good morning, Commissioners. I was approached by email by the evidence leader of the Commission sometime in March 2019 to provide information to the Commission on the Steinhoff Lancaster transaction involving the PIC. I appointed Mr. George van Niekerk of Edward Nathan Sonnenberg to assist, and via his office, we arranged a meeting with the Commission evidence leader and his colleagues.
Sorry, there's some confusion, it seems, about which statement was going to be placed before us, whether it's the latest or the previous one. We got one 2 days ago through which we went and got the latest when? This morning.
It would be the statement of this morning. I'm not aware of the earlier one would have been an unsigned one, I assume. Yes, it's the signed statement, Commissioner.
I'm sorry, but that's difficult because we've worked off the previous one. And I don't know what you're reading from. I mean, I had a copy this morning, but I've worked off a previous document. means that you're talking to something that I may or may not have in front of me.
But how different is it? Is it completely different from the one that was that we got in
It isn't it isn't completely different. It is different in some respects, and we had prepared on the one which we had the signed one that we had submitted to the Commission. That's the one which we would prefer to deal with if at all possible. The unsigned one was made available quite some time back, in fact, probably about 3 weeks ago. I would, with respect, if it's at all possible, be more comfortable leading my witness through the signed one. I don't think there's anything new, certainly not of import, in the that differs materially, but it is cleaned up, the one that we did presenting today, the signed one, in other words.
I want to just place on record then I'm reading a document, or you're talking to a document that I have not had the opportunity to read as I got it this morning, and I've based my information and my work on the previous document, and I need a copy, please.
Yeah, we'll ask a member of our staff to quickly make 2 copies for my colleagues. But we won't take a break for that. We can carry on.
I'd be grateful for that.
Yes.
We'll arrange for the copies to be made available to you now.
Okay, Bomi.
This is the one. This is the one. Mr. Commissioner, we have arranged for the copies. It will be with you within a minute or two. Can we
In fact,
proceed?
one copy would be enough because my colleague on the left has got a copy.
Yes, I do have a new one, I think.
Okay.
Yeah, that's right.
I'm indebted to the Commission.
Should I continue? As I was saying, I appointed Mr. George van Niekerk of Edward Nathan Sonnenberg to assist, and via his office we arranged a meeting with the Commission evidence leader and his colleagues and provided the Commission with information on the transaction. Subsequently, in July this year, I was advised by Mr. van Niekerk that the Commission evidence leader had requested that I attend the Commission in person. I agreed to this request, and my appearance was initially scheduled for 22nd July. This date was deferred by the Commission as its proceedings fell behind schedule. Subsequently, in early August, I was again requested to make myself available, which I again agreed to do. I provide this statement and attend these proceedings on a voluntary basis. The facts contained in this statement fall within my personal knowledge, save where the context indicates to the contrary. When I make assertions of law, I do so on advice of my legal representatives. In order to provide the Commission with a clearer understanding of my role in the so-called Steinhoff-Lancaster transaction and the manner in which this transaction was developed, I wish to briefly recap some background information. May I proceed? Okay. I was born in Durban in 1960 into a family of political activists. My father was president of the Natal Indian Congress from 1973 to the early 1980s, a political organization which had a strong association to the then banned and exiled ANC and the wider Congress alliance. My father's brother was a political prisoner on Robben Island from 1967 to 1972 and was my political mentor when he was released from prison. Fortunately, he was house arrested, so I had much time with him during the following years. I finished high school at the age of 16 and thereafter attended the University of Durban-Westville, where I began to study for a law degree in 1977. I joined the South African Students' Organization, SASO, that year. But shortly afterwards, it was banned, together with other organizations. I became active in student-based politics at the university and also became actively involved in community-based civic organizations in civic organizations, full stop. In 1980, I was actively involved in the student education boycotts and mass community-based rent protests in Durban. In 1981, I left university and became a full-time organizer of a trade union in the retail sector. I remained a full-time trade unionist from then until 1994. The union I was part of grew successfully, making a huge impact in the 1980s on improvements in wages and working conditions in the retail sector. I was personally involved in several campaigns for workers' rights and in the largest national strikes in the retail sector over wages in companies like Pick n Pay and the OK Bazaars, which later became a part of the ShopRite group in the 1990s. The union was a founding member union of COSATU when the latter was established in 1985. Subsequently, I became part of the COSATU Central Executive Committee and other COSATU structures. With the unbanning of political organizations and release of political prisoners in 1990, COSATU became involved in various negotiation processes. In 1991, in the negotiation process leading to the signing of the National Peace Accord, as a result of my track record, I was appointed as coordinator of the ANC Alliance negotiating team, comprising ANC, COSATU, and SACP delegates. The success of the National Peace Accord served as a prelude to the later CODESA political negotiations. In 1992, I moved to the COSATU head office as full-time national negotiations coordinator, in which capacity I led the Federation's work to establish the National Economic Forum, comprising government, business, and labor, as well as other multi-party fora dealing with various aspects of the political transition. In 1994, after the establishment of the first democratic government, I led the labor negotiating team that negotiated the terms of the NEDLAC Act, the first law passed by the new parliament, which gave effect to the establishment of the National Economic Development and Labour Council, a statutory body for dialogue and negotiation on social and economic policy and legislation between the government, trade unions, business organizations, and community organizations. In 1995, NEDLAC was launched, and I was appointed as its first executive director. In the first years of its existence, NEDLAC was at the center of change in the country, and much of the country's labor legislation was amended. Other policy and legislation, including, for example, competition policy, was also addressed by NEDLAC. In November 1998, believing the country to be on a path of peace and prosperity, I resigned from NEDLAC with the intention to start life as a private citizen. The day after I announced my resignation, I was approached by then Deputy President Mbeki to serve as the chief negotiator representing the presidency in a strategic procurement program. In that capacity, until the end of 1999, I led a team representing 4 government departments and engaged in contract negotiations with the international companies who had been appointed as preferred bidders by government. Negotiations were also undertaken with international banks from the countries where the preferred bidders came from. Once my task successfully concluded at the end of the year, I was then able to move on to pursue my own interests.
Sorry, Mr. Naidu, on that question, your strategic procurement program and that had been appointed as preferred bidders, in what area was this? What area of interest?
This was in the defense area.
All of these were defense contracts or companies?
It was the strategic defense procurement program which concluded in 1999.
Thank you.
Yeah, sorry, question here. And the union that you referred to, was it Sakao or Tausa?
Today, that union is SACAO.
Yes.
From the early period, there were many different variations of
Previously.
it and mergers and so on.
Yes, but it's Sakao now.
Today, it's SACAO.
Okay.
Thank you. In 2000, the year 2000 that is, I established a private company, the J&J Group, together with an old colleague and friend. Through J&J Group, we intended to create new businesses with high growth potential, strong social impact, and which could also be commercially successful. Over the ensuing years, we established several startup companies and invested in several businesses, usually in association with other companies with complementary skills. In 2001, the Old Mutual acquired 25% of J&J Group. As a result of an introduction by Old Mutual in 2003, J&J Group invested in Pepco Holdings, Pty Limited, who I'll refer to after this as Pepco, and we acquired 3.75% of the ordinary shares of Pepco. Pepco was at that time a private company, unlisted. The chairman and controlling shareholder of Pepco was Dr. Christo Wiese. The shares were acquired at market value on the same price and terms as all other shareholders. I became a director at Pepco and served on the board of Pepco for 8 years from 2003 to 2011.
A question here, and if you can, what was the deal size here? The size of the deal?
At that time, the size of the transaction was 100 million rands.
100, okay. All right, thank you.
As time passed, J&J succeeded in creating a positive balance sheet. However, it began to prefer a different strategy of investing in opportunities with lower risk, rather than startups or highly leveraged investments. Around 2009, the other co-founder of J&J exited the business, and several new shareholders entered J&J Group. Since that time, J&J began to exit some of its other investments and focus more on its infrastructure investments.
Do you mention the co-investor somewhere in the statement? Or
No,
you
I
don't?
do not.
Would you mind mentioning him?
It was J. Naidu, the other J in J&J. Commissioner Marcus is referring to him as Big J. And that's because in the trade unions and in the student movement, we both had the same name. And so, being older, I like to think is how he got the name Big J. Yeah. He has no involvement with the Lancaster Group. He resigned and exited at J&J level in 2009. Okay. In 2011, J&J Group exited its investment in Pepco, together with other shareholders, upon receiving a fair commercial offer from Dr. Wiese. I continued to have a strong interest in developing new business initiatives and in investment opportunities which involved higher risks with potentially higher returns. Over time, I became a non-executive in J&J Group, and in 2012, I established a wholly owned separate investment vehicle, the Lancaster Group, to pursue investments I was personally more interested in.
Sorry, Mr. Naidu, on the Lancaster Group, in other documentation that we've seen, especially in relation to the issues at hand relating to the Steinhoff and Sierra and Bluebuck, it's referred to as the consortium. Is there a difference between Lancaster Group and the Lancaster Consortium?
Where we may refer to the Lancaster Consortium, it would be where the Lancaster Group, which is wholly owned by myself, partnered with other entities.
Can you indicate who the other entities are in the Lancaster Group?
No. Lancaster Group is wholly owned. There's no other entity in Lancaster Group.
But it's then wholly owned by yourself?
Yes.
And therefore the consortium that went to the PIC to get the additional shares in Steinhoff were also the consortium was also wholly owned by yourself?
I'm not sure what consortium you're referring to.
It's the terminology used in the documentation, but if it's the same thing, that's what I was asking, is there any difference between Lancaster Group and Lancaster Consortium? If you're only referring to Lancaster Group, then that's the same thing that would be in our other documents, I'm assuming.
Yes, I'm only referring to the Lancaster Group.
And therefore that is wholly owned by yourself,
Yes.
singly?
Correct.
Thank you.
Through Lancaster Group, I acquired an interest in an IT technology venture directed at managing demand for electricity from end users. Although the venture secured patents worldwide for the technology, it did not achieve commercial viability for various reasons. The knowledge and experience gained in the electricity field came in useful, however, in enabling a resumption of business relationships with Pepco. In 2013, I was approached by Pepco management, who were interested in the retail opportunity for distribution of electricity prepaid vouchers, which they intended to grow in much the same way that Pepco had become a major player in the distribution of mobile phone airtime in the country. Given our previous relationship and my recent experience in the electricity distribution sector, we agreed to form a new joint venture between Lancaster Group and Pepco for the distribution of electricity prepayment vouchers. Following this, in 2014, I approached Dr. Wiese and we agreed on Lancaster Group investing directly as a shareholder in Pepco. Dr. Wiese offered to sell 2.5% of his shareholding in Pepco to Lancaster Group. At this point, I would like to address the issue of the role of Black Economic Empowerment, BEE, in the envisaged transaction with Pepco. And I'm referring to the transaction that I've just mentioned in 2014 between Pepco and Lancaster Group that Dr. Wiese and I had discussed. The primary driver for reinvesting in Pepco was the commercial value I saw in Pepco and the reciprocal commercial value that Dr. Wiese saw in my contribution at board level, my expertise on regulatory and economic issues, and as a strategic, business-minded colleague. By this time, Dr. Wiese and I had an active business relationship for 12 years. Furthermore, I had been involved in the retail sector in various ways, not only as a business person, for over 30 years, and I understood the sector well enough. To be clear, BEE has never been the sole determining factor in any business transaction I have been associated with. I consider BEE to be an ancillary aspect, and that becomes relevant only pursuant to a core commercial rationale between business partners. However, the transaction Dr. Wiese and I had agreed upon was overtaken by events when Steinhoff offered to acquire the whole of Pepco. The Steinhoff acquisition of Pepco was completed late in 2014. Dr. Wiese undertook to approach Steinhoff to continue with the original transaction as we had discussed, and arranged a meeting between myself and the Steinhoff CEO in the first half of 2015 to discuss it further. Thereafter, in or around June 2015, Steinhoff offered Lancaster Group an opportunity to invest in Steinhoff. Steinhoff was an extremely well-regarded JSE-listed, what I would describe as a blue-chip company. Many international investment banks had a relationship with Steinhoff as a result of their global profile. To raise the funding for this investment, I therefore approached a few international banks who I understood were interested in Steinhoff, including some based in London. I also engaged local banks and local development finance institutions, including the PIC. With Steinhoff listing on the Frankfurt Stock Exchange in December 2015, there was not enough time to implement the transaction in 2015. And the engagement between Lancaster Group and Steinhoff continued into 2016. During this process, one of the international banks I had been in discussion with introduced me to Symphony Capital, a local advisory services boutique, and recommended the company as a possible advisor who was very competent in raising capital using equity derivatives. In early 2016, I asked Symphony Capital to provide advice on the best solution they could find to enable the investment by Lancaster Group in Steinhoff. Symphony provided a proposal which entailed a capital guarantee via a put option against an investment-grade international bank. Symphony had obtained commitment for such capital support from a major international bank for up to 10 billion rands of investment by Lancaster Group in Steinhoff shares. I prefer not to identify the particular bank, given the existing confidentiality undertakings given by the bank. I accepted the Symphony proposal. I confirmed their mandate as advisor and therefore began exploring ways of raising funding for the transaction against such capital support.
Question here. Just in terms of the mandate, was it a risk-based mandate or were they paid?
It was a mandate with no retainer, totally at risk, and the success fee being payable at the end of the transaction if there was success. That constituted a level of investment by Symphony in a way, and also a level of comfort that we had a transaction that they believed was doable. It's a typical way of contracting on big transactions.
Okay, all right, thanks.
Although several banks were interested to provide funding, and I received indicative term sheets from several prospective reputable banks, no single bank counterparty had the capacity to provide this quantum of funding on its own, given their investment limits. However, the PIC was interested in investing further in Steinhoff.
Sorry, can I just refer back to the original document where you said in that circumstance, I then approached the CEO of the PIC, Dr. Machila. In this discussion about the PIC interest, was your interaction with Dr. Machila specifically, or was there a team that you dealt with directly?
My first approach was to the CEO, Dr. Machila.
You dealt with him before?
No, this was my first
This
time
was the
to deal
first
with him
time?
directly.
And did he, if you could just outline a little bit of the process, how that dealt with through Dr. Machila into his team, or what were the next steps taken, who you dealt with in the PIC?
Once we had reached the stage, which I'm dealing with in paragraph 26, where the PIC indicated an interest, he then referred the matter to his team.
Was that the end of his engagement with you?
From time to time during the process, we did have conversations.
With his team or with him separately from the team?
I had conversations with him from
With him?
time to time.
Directly between the two of you?
Yes.
Thank you.
I'll just go back to paragraph 26, where I said, however, the PIC was interested in investing further in Steinhoff. The PIC saw the benefit of the commercial nature of the proposal and was also keen to access the strategic influence that could arise from the relationship between Lancaster Group and Steinhoff.
Sorry, can you elaborate a little bit what you mean by the strategic influence?
The relationship between the controlling shareholder of Steinhoff, now with the management of Steinhoff having engaged with us, it was the relationship of working together. I was being invited to become a part of a leadership group. In that sense, there was more strategic influence that was capable of being associated with this transaction than simply buying a share through the stock exchange on the market in an anonymous way.
Dr. Machila, to the best of my recollection, and I could be helped if I'm mistaken on it, said that the purpose of doing it through Lancaster was that you will be able, they wanted to influence decisions and governance, and therefore supporting you to be a member of the board, and to be on the board you had access in a different way, and therefore this would allow them to exert different influence through you on that board. Would you agree with that?
It was a understanding of the investment that Lancaster Group was invited to make in Steinhoff, that I would become a board member. That is correct. And that was obviously a point of interest to the PIC, that they would have, if I can call it, a friendly on the board. And we had much in common in our view about developing the economy, developing entrepreneurs. So there was a meeting point between the PIC's philosophy and views of the world and my own philosophy and views of the world. So in that sense, I think it was not that I would be a formal representative of the PIC, but we would be aligned in our thinking.
And in that alignment, did you report back to the PIC on issues at any point in time about developments in Steinhoff?
Post the transaction, I obviously kept a good line of communication with the PIC on key issues. However, as a director, you have fiduciary responsibilities to the company, so I was careful to not cross the line between information that should not go into the public domain and information that could be shared. However, we kept up a very good communication. The PIC was also the second largest shareholder of Steinhoff after the Uppington shareholding.
So in that communication, recognizing the role and responsibility of fiduciary duty and keeping things separate, was it only in relation to you in terms of PIC, or was there interaction, say, through the chair, through others with the PIC as well as a major shareholder, or were they dependent on the communication from you?
I cannot answer what other communications the PIC may have had with other individuals that were on the board. You know, I think it would be surprising if their communication was only with me. I would think that they had open lines to everybody as the major investor in South Africa. But we kept a direct communication from time to time, and I think they appreciated that.
And that was with the CEO specifically, or with the team that had been part of the deal, or with their general corporate management interactions?
After the transaction, the doors opened, so there was communication at many levels between myself and the PIC and the deal team and the ESG team. There are many different pockets with responsibility for different aspects, and I engaged with each pocket that was applicable.
And that was specifically as Lancaster on the board?
It was as a board member.
As a board member.
In some respects, it was as an investor in Lancaster 101. In other respects, there were multiple sets of relationships and responsibilities and contractual obligations. We can deal with that later in the statement.
Yeah, those are different areas. Okay, thank you.
Going back now to clause 27. Following further discussions over the ensuing months, it was finally agreed between Lancaster Group, Steinhoff, and the PIC that a special purpose company would be established, Lancaster 101, through which Lancaster Group and PIC would partner and invest into Steinhoff. This transaction was consummated in September 2016 and was known by the project name Project Sierra.
Why Sierra and Blueback? You know, just those names.
I can't really explain. Somebody came up with that name and we adopted it. It was not me.
Or it came from the PIC side? Because they normally, you know, bankers give names to transactions.
No, neither of those names came up from PIC side. Project Sierra was a name invented by Symphony Capital.
Oh, okay.
I think they like to use cars for project names.
Okay. And Blueback.
Blueback was chosen by Steinhoff. They like to use animals.
Okay. All right. That's interesting. Yeah, that's interesting. Okay. Thank you.
I didn't use anything. I just used their names. Okay. We now go into the section Lancaster 101 Investment in Steinhoff NV. In September 2016, Lancaster 101 acquired approximately 2.75% of the issued ordinary share capital of Steinhoff. The shares were acquired by way of a combination of approximately 45% of it being directly through a subscription for new shares issued to Lancaster 101 by Symphony, by Steinhoff, sorry, I apologize. Approximately 45% directly through to a subscription of new shares issued to Lancaster 101 by Steinhoff, and the balance through an acquisition of shares from the market sourced through an international bank. Now, I've been advised by Advocate van Niekerk, Mr. van Niekerk, that you are well enough aware of put options and call options and collars, so I should kindly refrain from going on with clauses 30 to 33.
But if I could just stay with your clause 29 for the moment. Mm-hmm. As I understand it, then 29.1 would be roughly 60 million shares that you got through the direct subscription, and the balance of the 118 million shares through, so it would have been divided 29.1, 29.2, roughly 60 million, almost 60 million, roughly between the two. Is that correct? The total was 118 million shares.
Yes, yes.
Okay, and the total that was support provided by the PIC was 9.35 billion. Is that your recollection as well?
Correct.
Okay, we're going to come back to that later, but in terms of, just so that one's aware, that 9.35 billion in the evidence that was presented to us has now rolled up to a debt of 11.6 billion as at the end of February or March this year. You're aware of that?
It does accrue interest, correct?
Sure. So it's 11.6 billion that's outstanding.
I cannot confirm the exact number,
but roughly around that.
Should be.
I'm saying, I'm sure it's changed since then, but yes, that was the number that was given to us. That is really what the outstanding amount was at March 2019. February 2019.
That sounds right.
Okay, thank you. We'll come back to those issues after we've skipped the collar.
Just another question here. Just in terms of the shares that you acquired, did they have any super rights, rights in terms of the voting? Because we understand from Dr. Majila that there were parts of the shares with super rights.
They have no super rights. They're ordinary shares of the company. They have the same rights like every other share.
Yes, are we clear there? So just to repeat this, so the shares which you bought didn't have any super rights in terms of voting rights?
Those shares have
L101.
They have no additional rights. I think what is the correct way of representing the position is that through the investment, Lancaster 101 and myself as a director had voice in the company, had some special point of influence in the company, had some participation through becoming a board member and through the strategic association with the leadership of Steinhoff. But the shares itself had the same rights as every other share. Yes. It was not a special class of shares.
Yeah. So there were no shares bought from Tybolt or something with the super rights and all that?
We will deal with that later. That is not in this transaction. Yeah, this transaction we're dealing with is the acquisition of the shares in Steinhoff. The discussion about Tybolt I will come to when it deals with the other transaction in 2017.
All right. It might well be there. Okay, no, it's fine. Yeah, I think we'll check it there. Okay. Yeah, that's fine. That's fine.
Sorry, just before we continue, relating back to this transaction, the information that was presented to us was that you had originally gone to the PIC requesting 10.4 billion. Is that correct? For the Steinhoff shares?
Yeah, we had a support from the International Bank for a transaction up to 10 billion. So when we initially approached the PIC, we approached them on the basis of the full amount of support.
Okay, because
I can't remember the exact number, but it would be at the 10 level.
the information to us was 10.4 billion, and Dr. Machila in his evidence said they agreed to the 9.4 billion because his authorization did not extend above 10 billion, and it was the reason that they would have then had to go through other processes and boards, and therefore that's why they reduced it by 1 billion. Were you aware of that? Was that ever part of your discussion?
That discussion was held between deal team and the advisors that we had appointed, which is Symphony. And they came back at many points with their feedback on our approach. They reduced the size, they participated themselves in the upside as the PIC. They arranged for or insisted upon a new shareholder, which we will discuss later, the BE Trust, which is later they set up as the Lancaster Foundation. We had many different points of debate, which culminated in what they felt they were prepared to approve. We accepted that. It was not our proposals, it was the parameters that they produced.
No, I appreciate that, and it's really just asking whether you were aware of the thinking, whether it ever came to your attention that it needed to be below 10 billion in order to proceed without further approvals in the PIC process. Were you aware of that at all from your Symphony and other interactions?
I didn't take it as untoward. I took it as the counterparty, the representative of the counterparty was saying that in order for them, the PIC as counterparty, to approve the approach, these were the parameters they could live with. If we wanted to resist on any of the parameters, then they'd have, they may not approve it, they may take it to another level. So it was, to be frank, not something I delved into in great detail. It's the same with a bank or any financial institution. When you go for a loan and they say the credit committee is not so much interested, but if you would like more, you must go to the board or else fail. You live with the feedback of the counterparty representing the institution. So we simply accepted that it was good enough for the transaction, the parameters that they provided, and it was still commercial and we could live with that.
No, I accept from your perspective. I'm just wanting to understand that you were aware that this was a factor.
I was aware that that was as far as they could go before we risked no.
Or before it risked going to another level of approval.
Well, in any commercial transaction, when you refuse to accept what the person on the other side of the table is telling you is what he can do, and you want to test them by going to their bosses, you are at big risk that you are going to come with no deal. And one has to respect the assessment of the people you are negotiating with. They are the ones that you have to pay attention to. I would not dare to question the counterparty unless I felt that there was a better chance somewhere else. But there was no reason to believe that.
Thank you.
I'm now going on to clause 34, skipping the opportunity to educate about the call option and the put option. Due to the favorable specific circumstances associated at that time with Steinhoff, namely being a large company in which high volumes of shares were traded daily, L101 which is the way I'm describing the special purpose company, was able to obtain favorable terms on both the put and call options, resulting in a potentially highly positive return for L101 with limited downside risk. The PIC provided a loan to L101 for the purposes of the Steinhoff NV investment and received security over the proceeds of the ratio collar and a portion of the shares acquired. In addition, the PIC took 50% of the upside over the cost of the loan by acquiring 50% of the ordinary shares in Lancaster 101. It is important to clarify that notwithstanding the original proposal from Lancaster Group, the basis on which the transaction was finally agreed was that Lancaster Group's financial participation in L101 was limited to 25%, with the PIC directly holding 50% of L101, and Lancaster Group having the obligation to establish an entity which the L101 shareholder agreement referred to as a BEE trust after the transaction, and to transfer 25% of L101 to the BEE trust. What was called the BEE trust in the shareholder agreement was subsequently established as the Lancaster Foundation non-profit company. This was obviously after the shareholder agreement was amended to permit that change. The PIC entered into a loan agreement with L101, constituted, as I've just described, not with Lancaster Group, nor with myself.
Sorry, just when was the foundation established?
I'm going to deal with the foundation in a whole section
Okay.
later on. In addition, Lancaster Group proposed certain enterprise development orientated key performance indicators, which I will refer to as KPIs, that it contracted with the PIC to achieve inter alia, to promote black retail entrepreneurs in PIC-owned township malls, to promote the development of black suppliers to Steinhoff companies, to grow the performance of the Lancaster Group PEBCO joint venture in electricity, and to actively participate in further acquisitions by Steinhoff. Steinhoff also formally committed, as part of the transaction, to use its best endeavors to support the achievement of these KPIs by Lancaster Group, and communicated this to the PIC in writing. The PIC took the following security for the loan: a first-ranking security over any proceeds received by L101 under the put options, a first-ranking security over those L101 Steinhoff shares which were not pledged to the bank, a first-ranking security over any dividends received by L101, and a second-ranking security over L101's Steinhoff shares that had been pledged to the bank.
And just to ask also that the final deal was different to the deal which you presented at the beginning, isn't it? In terms of the metrics of value, of the value created.
I'm not sure I understand the question.
Yeah.
When you say metrics, what do you mean?
Yeah, the final transaction was different to the first transactions, just in terms of the payouts, future payouts.
This was the first transaction that was done between Lancaster Group, Lancaster 101, and the PIC. Obviously, it was different to the first submission of what we
Yes, that's
would have
what I mean,
proposed to them.
Yeah, the first submission is.
Yes, correct. But this was the first contract, if I can call it that. In the first submission, as Commissioner Marcus had raised, we had support up to a larger amount, but they came back saying they could deal with this amount, and everything then flowed from there. It was still, if I may point out, it was still the largest single stock equity derivative-based transaction that had been done in the country at that time. So there was no one feeling that you've lost status or standing with this outcome. It still was a bigger outcome than had been achieved in similar settings before.
I'll take you back a little bit because I don't see it, and it may be somewhere else in the version that we're working from. In your previous version, you indicate that the PIC subscribed for 50% of the ordinary shares, as you've indicated, and 50 million rand following the conclusion of the PIC loan and the ratio collar, which was paid to LL101, which was the equity in LO1 SPV, and Lancaster was also to contribute 50 million. Is that still the case?
Yes.
Can you just explain that?
Yeah. Commissioner, I'm just a bit surprised. The earlier draft was a draft, and we did get some feedback. The purpose of it was not to be a document for discussion. The purpose of it was to get feedback and then to finalize what we have done. But
I understand that, but you
I'm
also
happy with
need
the question.
to, but I also need to appreciate that we only got this morning.
I do
Right.
acknowledge that, unfortunately. In terms of the investment in the shares, the PIC paid 50 million for their 50%. Lancaster Group paid 50 million for its percentage. Eventually, that percentage came down to 25, but we did pay 50, and the remaining, we paid 50 on behalf of the BE Trust as well. So that was done. I think that's the question that you were asking.
That intended to be working capital, or what was it intended for,
Yes.
that 100 million?
Correct.
And then the information that I have was that your December management accounts show that there was only 130,000 cash in the bank. What was the 100 million still standing? I mean, is it still somewhere, or was it used, and what was it used for?
The money is still all there.
The money is still there.
It's all fully accounted for, yes.
In which account?
We have several bank accounts, but the money is within the accounts of the company. All the money that's been received has been accounted for, including money that's been received in the second transaction, all fully accounted for.
And just another question. Just in terms of the 100 million, the working capital, what was it supposed to be used for? When you say working capital, what do you mean?
It was then envisaged as a 7-year transaction, during which time it's expected that there will be several costs incurred over the period. So that was with that in mind.
Like the audits, doing the audits?
Audits, legal, various transaction costs. We didn't specify.
Yes, okay.
Okay, I deal now with the execution of the transaction. 3 business days prior to the transaction trade date, L101 issued a drawdown instruction for payment of the full loan value into an escrow account held with a local commercial bank. On the transaction trade date, L101 and PIC issued a payment instruction to the bank as escrow agent to firstly transfer into a bank account nominated by Steinhoff NV the rand equivalent for the subscription shares. Pay the bank for the additional Steinhoff shares acquired and the premium for the collar. pay the advisory fees to Symphony Capital. I'm afraid on this point, Commissioner, there is an error. There is either 1 too many or it's 1 too little. Yeah? Is it 1 too many?
Is it 76 million? If so, then
Yes,
there's 1
it's-
0
it's-
less.
it's,
1 too little. Yeah.
1 too little.
Yeah.
So pay the agreed advisory fees of 76,950,000 to Symphony Capital and transfer the residual balance of 22,850,020 rands and 48 cents to the L101 current account.
Sorry, and what was that used for?
I'm going to explain that in clause 40. For the avoidance of doubt, the entire loan amount, that is the whole 9.35 billion, was drawn down in favor of L101. And L101 accrued interest payable to the PIC from the moment the PIC paid the loan into the escrow account. The residual balance of the loan referred to above was obviously due to L101 and was transferred from the escrow account to the L101 current account. No additional fees were paid from that amount to any party. Specifically, I want to emphasize, Lancaster Group did not receive any payments or fees from the PIC loan.
Just a question there. In terms of that 76 million, it seems to be under 1% of the transaction. You know, how was this fee calculated?
The fee was set at 75 basis points, which is 0.75% of the transaction size. I had initially agreed to a higher fee with Symphony of 1%, but the 0.75 was one of the parameters that was communicated from the PIC that was as much as they would be comfortable to bear, and this amount included VAT. That was how it was calculated.
Just on that same question, I still don't understand what this 22.85 million was used for. If it went to Lancaster, what was it used for?
It was retained in Lancaster 101 account. And obviously there were some expenses which were due and payable, like these, at the closing, and there were other expenses that were expected to follow, that were going to be billed later. For example, legal costs. For example, share transfer tax on shares acquired from the market, not the issued shares, and so on. It belonged to L101, and it was retained in L101 and used in the ordinary course of business.
The team have requested documentation about that, and nothing has been forthcoming. Are you aware of the request? Of exactly how that 22 million has been utilized?
I've been dealing with the Commission through Mr. Van Niekerk since March, April, and I'm happy to engage with him if there's anything further there.
Can I also just ask about a SENS notice, which was issued in September 2016, that refers to the 60 million shares that were subscribed by Lancaster, fully funded by the PIC, that there would be a 2.5% underwriting commission. Can you explain that?
Yes. That fee was paid not by the PIC to Lancaster Group, but was paid by Steinhoff to the Lancaster Group. It was paid at the discretion of Steinhoff for the efforts Lancaster Group had made in contributing to what they saw as their capital raising efforts. They made a huge transaction beyond our transaction at that time, and it was a payment made in good faith. I did notify the PIC. It was reported publicly. The drafts of the statements were circulated for discussion. There was no objection at any time from the PIC, nor would I expect there to be an objection.
And if you had to look at that at the time, the rand amount would be about 110, 120 million.
Correct.
And although the PIC funded and paid for all the funding and supported, without which you could not have done the deal, that went to Lancaster, and the PIC was satisfied with that.
It was something that Steinhoff thought about at the last moment, and it was a good faith consideration from their perspective, and we took it as a good faith arrangement that was compatible with commercial logic.
Who at the PIC did you notify?
The deal team was notified. I mentioned that as well to the PIC CEO, and they all saw the draft draft SENS announcement and the final SENS announcement. It was public.
No, SENS obviously is public. The question for me would be, did the PIC pay attention to that, and were they satisfied that having funded the whole thing, that 110 or 120 million went to the beneficiary, if you like, for underwriting, when they're the ones who had paid for the whole deal?
They were fully notified.
They were fully notified at the CEO level?
At all levels.
At all levels. When Dr. Machila was here and we asked him about this, he said he knew nothing about it. Do you have any documentation to notify him, or did you sort of ensure that, I mean, a paper trail of the SENS announcement going to the deal team, or directly, was there any personal contact between you and the CEO over that matter, or was it through the deal team to the CEO?
I cannot recall exactly now, but there's definitely a paper trail because the drafts were all circulated by email.
Perhaps if we could just have copies of that, because as I said, when we raised that with the CEO, he said he knew nothing about the SENS announcement or that this amount of money was paid to Lancaster. Thank you.
Just to be clear, the 2.5%, on what value was it based at? On the 9.4 billion or on a different amount?
No, it was ultimately constructed as based on the amount that we subscribed for. So it would be on 60 million shares.
Oh, I see. Okay. All right.
I now go on to the next section, which is the second follow-up transaction, which is the transaction in 2017 involving the listing of Steinhoff Africa retail assets.
Can I just, before you go further, just on the last point, was there a time when maybe they felt that that money should have come to L101, not to Lancaster Group, you know, to be shared among the consortium?
There was never a discussion about that.
Okay.
In late 2016, Steinhoff made an offer to acquire Shoprite Holdings Limited, which was another major retail company controlled by Dr. Wiese. In December 2016, it was then announced that the transaction would no longer proceed as the management teams of the two companies did not agree on certain material aspects. Following this, in early 2017, I was approached by Steinhoff on a new plan which involved listing their African retail assets. And for that new listed entity, later named Steinhoff Africa Retail, or STAR, which was a short name at the time, to acquire a controlling interest in Shoprite. This would lead to an African retail giant with a large market capitalization which was well placed for expansion globally.
Sorry to interrupt you again. It was a question there, if I recall correctly, in Dr. Machila's statement, when we asked him about this initiation of STAR, and he said that originated as an idea and a proposal from the PIC, not from Steinhoff. Were you aware of a PIC initiative to do this, or was there something that came to the PIC as a consequence of your discussions in Steinhoff and Steinhoff board with you?
This was a conversation, the acquisition of ShopRite by Steinhoff was a Steinhoff initiative to the best of my knowledge. And when that transaction fell, as I'm going to deal with it now, it was Steinhoff that proposed a creation of an African retail giant through a listing of the African assets and then the acquisition of the controlling interest in ShopRite. So I think the idea originated from them. It was something that the PIC was very warm towards. So you know how these things can often be, that there's a coincidence of thinking. But in my sequence of events, I got the proposal first from Steinhoff. And then I took that proposal, as you'll see in clause 43, I took that proposal to discussion with the PIC. And if I can read that now, you'll see that there was a ready and willing acceptance of it. So in clause 43, I say, I thought it was a compelling proposition. I approached the PIC to discuss this opportunity. They were very supportive. So it may well have been that this was an idea that they had even before that conversation. And they were prepared to swap some of their ShopRite shares to acquire an interest in the new listed entity. There was also a new opportunity to invest in STAR at the listing. STAR would consist of major retail brands that were well known and understood in South Africa. As the new entity was to consist mainly of the old Pepkor business, which I understood well, and of ShopRite, I considered it a good investment opportunity. So too did the PIC and the L101 board. In discussions between Steinhoff, PIC representatives, and myself, L101 agreed to raise its own funding of up to 6.2 billion to invest in STAR, which L101 would raise from market sources, not the PIC. And Steinhoff agreed to match the L101 or affiliate funding in STAR. When I say or affiliate, it was the possibility that the funding may be extended to an affiliate of L101 and not necessarily to L101 itself. L101 was at that time a ring-fenced entity, so it was not able to transact in the same way as any other normal unring-fenced company can. The L101 investment would underpin the listing of STAR, and the additional funding, matching funding, provided by Steinhoff to L101 or its affiliate would be used to acquire shares in T-Bolt Square Financial Services, which I'm referring to as T-Bolt in the next paragraphs. And T-Bolt was the controlling shareholder of ShopRite. The shares to be purchased by L101 or its affiliate in T-Bolt, which, as I've mentioned, was to be funded by the Steinhoff matching funding, were later to be swapped into additional STAR shares after the acquisition by STAR of ShopRite had received approval from the regulatory authorities.
To come to my question earlier then, were these different types of shares, classes of shares with some super rights? Or they were just normal shares?
The STAR shares, that is the shares of the new listed entity, which we called at the time Steinhoff Africa Retail, were ordinary shares with the same rights as any other share. But T-Bolt, as an entity, had a special relationship to ShopRite shares. T-Bolt, in the MOI of ShopRite, has the right to have 30% voting shares, which are not economic, as long as T-Bolt holds a certain minimum number of ordinary shares. And hence, the acquisition of ShopRite through T-Bolt brought in a control dimension.
Yeah. Okay, all right. Now I get it. Thank you.
Thank you. For the purposes of receiving and applying the matching Steinhoff funding, an entity called Lancaster 102 was established as a wholly owned subsidiary of L101, thereby providing the existing L101 shareholders with the same level of economic participation in L102 as they enjoyed in L101. Due to JSE requirements in respect of the minimum size of the free float of STAR shares, the Steinhoff funding commitment to L102 or its affiliate, i.e. to L101 or its affiliate, i.e. L102, was later reduced to 4 billion instead of matching the 6.2 billion L101 investment in STAR. Steinhoff committed to address the shortfall by providing an additional 2.2 billion rands of funding to L101 or its affiliates for future joint investments on similar terms.
Can you elaborate on where that stands now in terms of both the 4 billion, the 2.2 billion, and what actually is the circumstance at this point in time?
I will come back to the 4 billion because I deal with that later in the statement, Madam Commissioner. In terms of the 2.2 shortfall, there has obviously not been any further transactions, so that shortfall is unaddressed, and there is also not much likelihood of a transaction. So I think safe to say the matter is open and unaddressed. Clause 48, L101 funded its participation in STAR by agreeing new security arrangements with the PIC to enable L101 to raise third-party bank financing against the put option proceeds under the ratio collar. To this end, L101 once again mandated Symphony Capital as advisor due to their familiarity with the existing position of L101, and through Symphony, we approached several banks to quote on funding terms before selecting the best quote, which came from the same bank that L101 had transacted with in Project Sierra, incidentally. However, it was not given that that same bank would get the opportunity to provide the funding. It was a coincidence because of the competitiveness of their quote. The PIC security package for its loan was therefore amended as a result of this transaction as follows. A primary cession and pledge was effected in favor of PIC over the ordinary shares in STAR, which had been acquired by L101. Then the PIC security package was a reversionary cession and pledge, i.e. a second-ranking cession and pledge, which was effected over all of the Steinhoff shares that had been acquired by L101, over which the bank now had first-ranking security, as well as the put proceeds under the ratio collar, and the security held by L102 in respect of the Steinhoff funded investment in Thibault.
So are you saying then that the 25% of the L101 shares that were held by the PIC were lost into the Star security package? They were taken by the bank?
I put it in this way, not
Yeah.
lost, but
Yeah.
the first ranking security that the PIC held over some of the Steinhoff shares, which you will see in the earlier clause that I mentioned that there was a first ranking security, they now ceded that. That was now the first ranking security of the bank. The bank held first ranking security over all of the Steinhoff shares. The PIC's security rights were now second ranking. They were reversionary rights.
Yes.
And the put proceeds that were first ranking security of the PIC in the first transaction, Project Sierra, those were now first ranking security of the funder that came in on this
In Star,
transaction.
yeah.
In this transaction.
Yes. And so in terms of security package in L101, what did the PIC have finally at the end of the Star transaction?
So they had first ranking security over the Star shares that we bought.
Yes.
They had second ranking security over the Steinhoff shares and the put proceeds. And then they had second ranking security over the asset that we had in Thibault.
But they completely then lost the L101 security completely. Can you say that?
No, they didn't
Yeah.
lose it because it was
Second
the
ranking.
first ranking security only applied to the extent that the value of the collar, to go to the collar, which we didn't discuss, the spread between the put strike and the call strike still belonged to L101, and the PIC still had security over that before the economics of the call strike became applicable, which is what the bank. So the bank security was securing its position, but we still had economics in the L101 investment.
Okay. Maybe just to put it in another way, if the share price of Steinhoff fell by 70% in L101, what security did the PIC have? Let's put it in that way.
That security,
What could the PIC salvage?
no, that security was ceded to the bank now.
Yeah. So there was no, if the share price had to collapse, the PIC didn't have any security in L101.
The PIC's security was now represented by the benefit it had over the Star shares.
Yes. Okay, so it's a counterbalancing force in some ways, in a sense that it lost the security in Steinhoff, but it was counterbalanced by the shares in Steinhoff.
Yes,
Is that correct?
correct. If, for example, the share price had gone up by 25%, then the value of that gain would have been the value against which you still had relevant security in terms of the PIC loan. But from the put strike downwards, that benefit belonged to the new funding provider.
Sorry, just to stay with that 1 second. So if I could try to understand it, in essence, the PIC security was seriously diluted. In order to enable the transaction, that security was transferred to the bank or the funding entity, and that it actually relegated its security in order to enable that funding to take place. Because that was the condition, as I understand it, that that funding would be provided from the bank.
Yes.
Is that correct?
There's a at the time view and a hindsight view that I think one can consider. At the time, it made perfect sense because one was leveraging one's existing position to raise effectively up to another 12 billion rands, in which the PIC didn't have to spend any money, to get exposure to two assets, Steinhoff and Star, as well as Shoprite. And if all things were equal, every model that was done showed how beneficial this would be, because the cost of the funding was fairly low in commercial terms. In hindsight, with the effect of the what is now widely understood to be the biggest corporate fraud in South African history, PIC sacrificed something which at the time did not look material. To protect against the downside looked like a lesser objective compared to getting more of the upside. But in hindsight, if we had an ability to see into the fraud, then we would have valued the protection more highly, and the PIC would have valued the protection more highly.
If the PIC was to liquidate at this point in time on both assets, given its investment in both, and we know that, as we discussed earlier, on the first it's about 11.6 billion. If it was to liquidate, would there still be losses offset? What would be the extent of the loss taking the Star investment, the LO1, LO1, 2, Bluebuck, the shares in Steinhoff, if that was to happen? What would be the extent if you had to quantify it at a moment in time? Now, what would that loss to the PIC be? And obviously, we do understand fully that the Steinhoff issue and the Steinhoff fraud is material to the outcome that we're facing.
So, in order to liquidate, there's a whole range of legal rights and obligations. So, I won't go into that now. But it's not possible to go to that at this time, as I see it. However, to answer what I think you are asking, which is the current value of the position and the nature of the loss, the GEPF and the PIC do a mark-to-market test from time to time to establish on any point in time what is the value of the asset if it could be sold. And obviously the major asset that has value is the Star shares, which has held its value, although it has also been dampened by the fact that there's a huge overhang on the Star shares as a result of Steinhoff's 71% shareholding in that asset. But I don't have the exact numbers, but it would be a sizable loss on the mark-to-market position. I think the GEPF would be better placed, or the PIC, to give you the numbers, but it is sizable. Relatively speaking to shares that were held in an unprotected environment in Steinhoff, which lost 98% of the value, then you would think that this is a much smaller number. But it is still a sizable loss, but it doesn't compare to losses in the ordinary listed shares.
Thank you.
Just to follow up there, so how would you look at the numbers? I mean, is Star still worth around, you bought Star for 6.2 billion rands. Where would that shareholding be now? Would you know? Is it higher? Is it lower?
On a current daily price, last time I looked at the Star shares, it was 15% lower.
Lower, yes. So it's under 6 billion rands and all that. Yeah.
So it's less.
Yeah, less than that. Yeah. So meaning that, just roughly, we're just talking. So if you look at the loan, as it was said, it has gone up to 11.6 billion. And the Star shares are under 6 billion. the Steinhoff shares are 98% down, you know. So, I mean, on a mark-to-market basis, it will be quite a lot. I mean, the loss would be like 11 billion if you include the interest, more than the 11 billion rents. And even, isn't it that the 6.2 billion rents, the PIC only owns half of that, isn't it? Because it goes through L102 to L101. Is that correct?
Yes, so the PIC loan has first-ranking security over the Star shares. So
Yes.
100% of the current value of the Star shares is applicable against the loan. So
Yeah.
it wouldn't be 11 billion rand loss.
Some loss there.
If you only had Steinhoff shares, it would be 11 billion rand loss for sure.
Yeah.
But in our construct now, it is less, but it is a lot,
Yeah.
without a doubt. You know, you can work out the numbers there. It's not for me to say the numbers, but you know, it's not difficult to take a stab at that.
Sure. Then broadly, then you would say the mark-to-market loss is around 11 billion for now.
I wouldn't say that.
You wouldn't say that.
No, it's not that.
It's less than that.
Yes.
And then you take the Star shares, you offset by the Star shares.
Correct.
Okay.
And then, of course, one has to hope that the claim, which I will deal with later, but is worth mentioning now, we have instituted a claim for 12 billion rands, roughly, for the total value. And so one hopes to get some recovery through the claim.
Okay.
Okay, I'm now...
But just to be
Sorry.
clear, just the one thing, what percentage of the Star shares that the PIC hold?
The PIC on its own, I don't recall.
On a see-through basis?
No, they don't own the shares on a see-through basis. They have the economics through the security arrangement, but L101 owns 8.7% of what is today called Pepco, because the company changed its name from Star to Pepco. So it's L101 owns 8.7% of the shares in issue.
And the PIC has got half of that company, owns
Yeah,
half
the
of
PIC has security over all of it and owns 50% of the shares in L101.
of the shares, okay.
I think they themselves, directly through their listed equities portfolio, own another.
No,
bunch of
it's fine. I
shares.
think we'll get the correct mark-to-market value from the PIC. It's fine. Thank you. We'll get that.
I then deal with the, I think, was it clause 50? The PIC duly released its security over the Steinhoff shares and the revised security arrangements in respect of the Star shares and the collar were effected prior to the closing of the transaction. The execution of the new security arrangements over the L102 assets was effected shortly after the closing of the transaction. There are no outstanding conditions that are unfulfilled in this regard.
Sorry, before you move on to that, I've got a question that has not come up off your text, but it relates to the whole question of the L101 funding to participate in STAR. And it says the essence of it was 6.2 billion to the subscription of around 302 million ordinary shares in STAR at 20.50 Rand per share. That was the one element. The second element was the balance to general corporate purposes, value-enhancing strategies, and transaction costs. And that amounts to 280 million rand. If the loan was 6.2, where did the other 280 million rand come from? Of which 150 million was the value-enhancing, and we've dealt with that a little bit, but the other parts was capitalization of the trust, which was 50 million. The value-adding strategies, 150 million. Transaction cost to Symphony was 49 million, and the PIC was paid 30 million for restructuring. So that we know how it was allocated. What I'm asking is what's the source of the funding?
Oh, okay.
Because there's no reflection of where that addition, in any of the numbers that I've seen, where that additional 280 million was either provided by the PIC or authorized by somebody. So where did that money come from?
The money was all raised from the bank. So in giving the bank security over the put proceeds, the question is, what was the net present value of the put proceeds, which is what equated to the amount of capital that we received. So the nominal value that was protected was 9.35, but the present value of it was less because that value became full only on the final date when you collected the money. So since it's a long term, ultimately 7 years, the current value of it was less. So it's like, if you buy a car now for a certain amount of money, but you're going to pay for it in 7 years' time, the cash that is given now is a different number compared to the nominal value of it later. So the nominal value changed from the beginning to the end. Each day that we went along, there was a bit more that was in the net present value, and also the discount rate that is used also creates a positive effect. And this is where I think advisors like Symphony can pay for themselves by adding value. So the whole amount came from the bank. I think that's a long story short.
But we're talking Blue Buck 6.2 billion, not Sierra. Because
Not
as far
Sierra,
as I'm,
Blue Buck.
it's
It
Blue
was
Buck that was 6.2 billion.
6.2 of the proceeds that were raised from the bank were applied to Star.
Yes.
And the remaining amount of the proceeds was applied to the remaining amount.
So there was an additional 280 million raised from
Yes,
the bank.
yes.
And that is part of the obligations that you have to service. It did not
Yes.
come from the PIC.
No, not at all.
Okay.
The
thank you.
PIC has only
The original
provided
amounts.
funding once.
Okay. Thank you.
Okay, clause 52, is that the one we are now? Yeah. Okay. On 5th December 2017, the Steinhoff board announced that PwC had been appointed to conduct an independent investigation into accounting irregularities. Mr. Marcus Euster had resigned as CEO, and Steinhoff would only publish its audited 2017 consolidated financial statements when it was in a position to do so, and would determine whether any prior year's financial statements would need to be restated. Subsequently, Steinhoff informed the market that its 2016 consolidated financial statements would also need to be restated and could not be relied upon. Further on, Steinhoff announced inter alia that the 2015 and 2016 financial statements could not be relied upon. As a consequence of the accounting irregularities, the share price of Steinhoff plummeted, resulting in significant losses for its many individual investors, sovereign wealth funds, private asset managers, banking institutions, and others, including L101. The Steinhoff events described above led to the unwind of the L102 position in T-Bolt. T-Bolt had invested the 4 billion rands they received from L102 into a preference share issued by Steinhoff, specifically Steinhoff Africa Holdings. Upon the unwind, L102 received this preference share in exchange for the T-Bolt shares, which it gave back to Titan. In April 2019, after the publication by Steinhoff of the summary of the findings by the PwC investigation, L101 instituted legal action against Steinhoff for the recovery of the investment made in 2016, the matter is currently proceeding.
Can I just get clarity on the 4 billion?
Yes.
Because as far as I understand, you indicated as a debtor in L102's management accounts for December 2017 and for 2018, plus interest of 80% of prime. Does this mean, in essence, it was never settled, or is it something that was an in and an out and it's actually neutralized and therefore will not reflect in your accounts in future, or what is the status of that 4 billion?
Okay. In the context of, legal claims, one has to be careful how one answers the question. But I would say there is, it's not an in and out. Lancaster 102 raised 4 billion at that rate from Steinhoff. It then invested that amount in T-Bolt. T-Bolt then invested that amount in a pref share that Steinhoff issued to T-Bolt. When the ShopRite leg of the transaction failed through all of this, in terms of the unwind provision that was in place, that had to be in place, that if the regulator never approved, then we had to unwind the transaction. We then ended up receiving a pref that T-Bolt had received from Steinhoff for 4 billion, which was on the same cost. So we have two prefs, one which we owe, one which we owe. It turns out, of course, that the performance of the pref that we are owed has, of course, performed better than the star shares. But that is, you have a matching asset and a matching liability. But the legal interrelationship between these two is another matter. So it's not obvious that they are simply accounting entries that can be cancelled. They have other differences in the terms between the two.
Okay, thanks. That clarifies that.
Just another question. You know Steinhoff pretty well, it seems. You know it pretty well. Just in terms of the claims in its future, I mean, it's a holding company, Steinhoff. So it looks like it does have some value somewhere. Where do you think Steinhoff is going in terms of, value-wise into the future? Its assets, its subsidiaries, can they be sold at good amounts, or can they keep them? Can it succeed in the future, or it's a lost cause?
Yeah, that is a question which is hard to speculate about. I think the new leadership team of Steinhoff have done an excellent job to keep the ship afloat. And you will see, even in the newspapers today, the company voluntary arrangement that Steinhoff was working on for over a year has now been perfected. And so the debt is all in a lock-up phase till the end of December 2021, which gives them an opportunity to try and settle claims, settle creditors, and create some value from the assets not being disposed of at distressed values. But having said that, it's still a very difficult job, because the sum of the creditors and the claimants far exceeds the value of the assets. So, it's unlikely that you will see a lot out of there, But nevertheless, we have a substantial claim at the holding company level, and we will be pursuing that claim vigorously.
Are you saying that the creditors' claims are bigger than the assets, just the creditors' claims?
The creditors themselves, that is the proven creditors, whereas the claimants are contingent in that they are not yet proven. All right. it's also arguable, depending on the value of the assets, whether the assets and the liabilities are matched or whether the liabilities exceed the assets. I can't give you a definitive answer about that, but just through a casual look, you'd see that they don't look far apart. So it all depends what values you allocate to certain of the unlisted assets that are inside of Steinhoff. But it's arguable that they may also, even at the level of the creditors, have more liabilities than assets.
So it looks likely that the shareholders themselves might not get a cent.
I'm not qualified to give
Yeah,
anyone
okay,
investment
no, that's
advice on
And
whether
that's why
they
I
should
say
invest
might.
in Steinhoff.
Might.
Yeah.
Yeah, that's why I say might, but yeah, that's in the future then, once they've dealt with the creditors, I guess.
You'll have to ask me over a
Yeah.
cup of coffee for
All right,
investment advice.
thank you, thank you.
Okay, I now deal with the Lancaster Foundation non-profit company. As described earlier, at the behest of the PIC, it was agreed that 25% of the shares of L101 would be reserved for a BEE trust to provide grants for black community social development and concessional financing for black enterprise development. The shareholders' agreement provided that Lancaster Group would establish the new trust and sell down its shareholding in L101 to the trust at par value, such that the final shareholding of L101 would reflect the PIC with 50%, the BEE Trust with 25%, and Lancaster Group with 25%. After receiving legal advice, the initial L101 shareholders, being both the PIC and Lancaster Group, approved the amendment of the L101 shareholders agreement to permit the establishment of a non-profit company as an alternative to a trust. The Lancaster Foundation non-profit company was established in 2017 and was allocated shares in Lancaster 101 in accordance with the terms of the L101 shareholders agreement. The non-profit company's main objects permitted to provide grants or concessional finance to recipients as determined on a case-by-case basis. In addition, the MOI of the non-profit company restricts it from directly or indirectly paying any portion of its income or transferring any of its assets, regardless of how the income or asset was derived, to any person who is or was a director or a person appointing a director of the non-profit company. L101 has provided the non-profit company with an initial amount of 50 million rands out of the funds it raised pursuant to the refinancing that occurred in 2017 to enable the non-profit company to commence its activities without having to wait until a future time when dividends are paid to L101 shareholders. The non-profit company has not employed any full-time staff, and its directors receive no remuneration for their work. For the avoidance of any doubt, I record that none of the directors are beneficiaries of the foundation. No family member of mine is a beneficiary of the non-profit company, and no one connected to the PIC is a beneficiary of the non-profit company. All its activities are conducted at arm's length.
Thank you for that. You say that the question is no one is a beneficiary. Again, just for the point of, for the sake of clarity, because allegations are that it is your daughter who runs this foundation, is that correct?
My daughter is a director, non-executive director, as I am. She receives no remuneration, no fees, and she has received no benefits from this. She does her work as a director.
Can you name any of the other directors?
Roshan Morar is the third director. He was the independent director
On the
appointed
PIC
on
board.
L101 board by the PIC.
See. Are those just the three of you
Just
then?
the three.
Thanks very much.
I now have come to the end of my statement. I noticed that I didn't have any concluding flourish. So, Mr. Chair, I am in your hands now.
Are you thinking of other flourishes?
Yes, well, I suppose the concluding point would be that, at the time, the investment by the PIC in L101 and the construct of that investment was one of the largest, and it was done at a time when we were very optimistic about Steinhoff's future, heading to prime position in the top 10 of South African listed companies. I think in the final analysis, this investment has been disrupted by the corporate fraud that we have all seen, which is most unfortunate, but it was external to anything that anyone envisaged.
Yes, thank you. We take note of that. Any further questions?
Thank you. Mr. Commissioner, the issues and topics addressed by Mr. Naidu in his statement are those matters that we engaged with him and his legal advisor previously. So from our side, we covered. There are still some documentation that the forensic team will obtain from Mr. Fanika. That will be arranged. So from our side, I have no further questions.
Thank you. It remains for me to say to you, Mr. Naidu, thank you very much for your time. Thank you for giving us the information that we really needed. Like all the other witnesses' testimonies, yours was as important, and we'll certainly take it into consideration. Mr. Van Niekerk, was there anything that you'd like to say?
No, nothing further to add. Thank you, Commissioner.
Thank you, too, for your being here to assist your client. You are excused together with Mr. Naidu, but I'm going to issue a statement. If you want to sit, if you want to leave, you can do that. Okay. Yes, this is the Commission statement at this stage. The PIC Commission of Inquiry, established in October 2018, held its first meeting on 2 November 2018 and began formal hearings on 21 January 2019. To date, 77 witnesses have publicly testified before the Commission, a number of them appearing more than once or sitting for a few days. The Commission's interim report was submitted to the President Ramaphosa, as scheduled on 15 February 2019. Since then, the term of the Commission has been extended twice, from 15 April to 31 July, and now from 31 July to 31 October 2019, when we will submit our final report to the President. Today marks the end of the scheduled public hearings on allegations of impropriety at the PIC as outlined in the 17 terms of reference that guide the work of the Commission. It is now our task to review, assess, make findings, propose recommendations, and prepare our final report in keeping with these terms of reference. In addition to the investigations and testimonies that have been presented to the Commission over the past 8 months, further possible questionable transactions have come to the attention of the investigation team. The team will continue with their investigations and, if deemed appropriate and necessary, further limited public hearings may be held. Furthermore, anyone with evidence or who has been mentioned in evidence to date and wishes to place their version of events on record are welcome to submit their testimony by way of sworn affidavits, and all such submissions will form part of the testimonies that will be considered by the Commission when writing our report. In the period between now and 30 September 2019, Advocate Libber and his team remain available as the point of contact with the Commission. Our communications team will alert the media if and when any new documents are posted on the website. We extend our appreciation to all those who have given testimony before the Commission, often in difficult personal circumstances. We thank the media for their consistent coverage of the work of the Commission. And I note there are certain faces that I've seen every day during our hearings, and we appreciate that very much. Thank you. We shall now adjourn.
Thank you very much. Thank you. See you again.
Before you do so, Mr. Commissioner, may I have the last word? With your
Certainly.
leave. Thank you for this closing address, Mr. Commissioner, but I'll be failing in my duty as the evidence leader not to tell the Commission that the legal and forensic teams are deeply indebted to the Commission for their guidance, the patience and assistance during this, what I think was a roller coaster ride, which is still going on. And we also wish to thank from our side the admin staff, for which we could have not been able to perform our functions. To the media, printed and electronic, for mostly covering in a very fair and objective way the proceedings before this Commission. And lastly, I would thank and convey the deepest thank of my teams to the PIC for their assistance during these proceedings, and in particular, Wilna Low and Dion Botha, who were always available, night and day, to assist with the procurement of documentation or evidence that was needed by the teams. Thank you very much, Mr. Commissioner.
Thank you, Advocate Libber. Now we shall adjourn.
Thank you, Nadine. Let's go.